Hello everyone, welcome you all in this session. Myself, Assistant Professor Ripal Gupta from LJ School of Law. So today we'll discuss the subject of administrative law and in which we are going to discuss the topic of exception to natural justice. We have already discussed about natural justice, now we'll see the exception to natural justice principles. So first exception to the rule of natural justice is statutory exclusion. So we have learned that natural justice has not been defined in any statute, but we just for a socialized society in a self-mannered ways to give the fair justice for natural justice. So it is somewhere silently described as a natural justice. So it is not supplement to law, but it is supplement to the law. So it is a need for giving a fair justice. But if the statutory authority has mentioned something about the natural justice that certain principle will not adopt by this statute, then it may be considered by the court that they will not consider this natural justice principle in that act. So if any act defined that this cannot be first example, cross-examination cannot be entertained in such matters, then court has to adhere by that statutory expectation and their rule that they cannot follow the cross-examination in any matters. So when there is a state authority mentioned about exclusion of certain principle of natural justice, there is an exception to the principle of natural justice where court has to go with the statutory principles, not with the natural principles. Second is exclusion legislative functions. So basically legislative functions not only make the laws but they make the procedures for it, they levy the taxes, fix the prices for this. So sometimes in their function they may exclude the natural justice principle because of the generalization of certain things in the society. So for that if they are making they're excluding any principle of natural justice over it can be exception to the natural justice and can be considered by the court. For example, to fix the prices or for any manufacturing of any trading any things, the restrictions can exclude the natural justice principles and this can be considered by the court because it's their function and they can exclude any kind of natural justice principle for the generalization of the principle in the society. Next is exclusion in emergency. Sometimes in emergency cases, the authority has to take decision without asking anyone and without considering the natural justice principles. It may be a situation where there is emergency in case of prompt and preventive emergency. We need to take care about it. Then the authorities can take steps without asking anyone. For example, if there is a building which can be demolished because of its construction, then without asking to anyone, they can demolish the building because it is for the protection of the people. So any such kind of steps has been taken by the government authorities without asking the natural justice principle, it can be considered. So here in Krishna here says that if the condemned unheard is wrong, it is wrong except where it is overborne by these tier of social necessities. If there is a social necessity for the people that they need to exclude the natural justice principles, the authorities can have power to exclude the natural justice principle. Next is public interest. Sometimes for the public interest, they need to exclude the public natural justice principles. For example, there is a requirement of that. There is of course a requirement of notice and hearing in the principle of natural justice, but that may be override by the authorities when there is a necessity for the safety of the people, for the public interest. They have to take certain steps which can they may not serve you notice, they may not give you chance of hearing, then it is then they have to prove that it is for the public safety, for the public interest. For example, demolishing property or demolishing contagious plant or extinguish fire. These are the examples where without asking the people they can take steps over here for protecting the people. But in this situation, they have to see that they should not commit any mistakes which may result into infringement of the rights of the people. So for the public interest and for the public safety, yes, sometimes the government can exclude the principles of natural justice. The next is exclusion based on impracticability of the situation. Sometimes the situation is so impractical that we cannot hurt all the parties. For example, if we take the current example of corona, because of due to corona, the last semester exam has been or that only last such exam can be conducted by the Gujarat University, not the other examination. So if they have any kind of problem with this situation and they want to be, you know, they want to they want to raise the issue of that case, it might possible they will not hear all the person, not all the students. So here the principle of natural justice to being heard cannot be cannot be fulfilled by the judiciary because they cannot hear every parties. So if there is sometimes it may be possible because of the large number of the people they cannot hurt each and every person. So here they can exclude the principle of natural justice on the basis of impracticability of the application. So this again be a exception to natural justice. Next is exclusion based on the academic evaluation. Sometimes the students who are not performing very good in their academic arena, they are being detained without giving them chance to be heard. So this can be a possibility when if they are not doing well for many times they cannot be given a chance to be heard and they can be excluded from their college or from their academic arena. So again, this is exceptional natural justice when that in academic evaluation, if that person is not performing well, the college or the university has the right to remove that person from if that person is not performing well. Next is exclusion in case of interim disciplinary action. Sometimes to keep peace and discipline in society or in any establishment, they make such a rules and procedure where they exclude certain natural justice principles. So it cannot be said that they have infringed or violated the natural justice principle. But if they are for the maintenance of the discipline, they make such a rules for that particular point of view. It is very fair that they cannot be said as violative of natural justice. In the case of Abhay Kumar Srinivasana, in case of Delhi High Court say that such an order could be compared with an order of suspension pending inquiry, which is preventive in character. That means a disciplinary action is a preventive in character in order to maintain peace in the campus. So, and therefore, the principle of natural justice cannot be attracted. So, if for maintaining peace in the campus or discipline in the campus, any university makes such a rules which excludes the natural justice principle, it cannot say they are violating the natural justice principle. It says that they are making rules for maintaining the peace and discipline in the campus. And the last is contractual transaction. In the case of State of Gujarat versus MP Shah Charitable Trust, Supreme Court says that if any party is breaching the contract or contractual terms, it cannot be said that he infringes natural justice principles. Any contractual obligation, if they are breaching any contractual transaction, it cannot be said they are breaching the natural justice principle. So today we have discussed about the exception to natural justice. There are certain exceptions to the rule of principle of natural justice. So we have seen this territory, legislative actions, and certain procedures like courts or the impracticability or the universities or the academic evaluation. These are certain exceptions where you can exclude the principle of natural justice. Thank you.